going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Sunday. I hope you guys had a great weekend. Back to the grind tomorrow. Tomorrow's going to be fun. I've got a lot on the calendar for this week. It's going to be a good week, guys. It's going to be a great week. Can't wait. Hope you guys are doing well. I've got a great show for you guys tonight. Got 5 or 6 different clips, mainly because Friday night sucked. I am a big critic of myself, and I was not happy with how Friday went. So I'm gonna make a little bit longer show tonight. I was more careful on picking the clips. So I picked out some good ones for tonight. I hope you guys enjoy them. Before we get started, we've got a new member, Bob. Welcome to the family. Thanks, Bob. Appreciate that. I love saying thanks, Bob. Thanks to Sideman Dan. But Bob, thank you very much. I do appreciate it. And Nanya Business for 8 months. Thank you so much for the 8 months, Nanya. I do appreciate that. To give Colin something to talk about at the start, I appreciate it. I do. I do struggle with my intros sometimes. Thank you so much, Nanya. I appreciate it. All right. You guys want to watch some court? I want to watch some court. Yeah. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mr. Biffle.
Yes, sir. I'm trying to straighten out I had to put it on charger. I apologize about that, sir. I don't use my laptop every day.
Real quick, just because I saw a couple of you talking about Biggins' channel, I think he just didn't know you. Well, I think he knew he was muted. He might be having mic issues, but he still rated Artie, so I don't think his stream just stopped. I think he stopped when he planned to. He just was muted at the end. I think that's all it was. All right, now let's go.
Can you hear me?
Biffle, you were an hour and a half late. I already issued a bench warrant, so I don't know what to tell you.
Judge, I was hoping that you would understand I wasn't trying to miss the case. It was just that I worked so late with the water department yesterday. I didn't get home till about 12, and then I still have custody of my youngest daughter, so I kind of overslept this morning. She didn't even make it to daycare. And I know that's not your problem because you're at work and you're doing what you're supposed to do. But I will ask you not to issue a bench warrant because I'm trying to get this taken care of, and I have custody of my daughter, and I don't want to be pulled over and the police have to take my daughter to a foster care or anything like that.
Mr. Biffle, the challenge is that this all feels like one big giant game. We're now on our third defense attorney. We're now on multiple times where you don't show up on time. My frustration about today is I went back and I listened to our conversation on November 16th, and I found it. Let's see if I can share it, because I remember specifically having the same conversation with you a couple weeks ago. So let's see here. And Ms. Rosenau, please tell me if you can hear this once I start playing. All right, so.
I love how Judge Meineke checks the receipts. He brings up his YouTube channel and he looks at the guy's last appearance. It's the second time we've seen him do this. I love it. Like, oh yeah, we're not going to have any confusion. Let's go back and see exactly what happened. Let's do that. Ascalis, thank you so much. I appreciate it. Thank you so much for the 4 months. Thank you. And also, as always, thank you for the phonetics in your um in your name. It does help me out a lot.
Well, I'm going to give you your next court date.
I'm ready, sir.
Okay.
Yes.
So that you can have it. You can write it down even before it gets sent. Any of those things. Okay.
I have pen and paper here.
Okay. So I'm going to set this for a probable cause conference. I'm going to order new MIDC counsel. I'll allow Mr. Lynch to withdraw. And let's see here. we'll set this for, I can do next Friday or this December 6th. Is there,
Can
do
you
you
give
have a
me
preference?
You're asking me, Your Honor?
Yeah, do you have a preference?
I take it as soon as you can get me a counsel. It can be next Friday or the 6th. It's up to you, Your Honor. I don't have a preference because I don't have the money for a counsel right now.
Okay. Well,
Judge,
just
you
to
do
play
know I
it
spoke
safe,
to
so
my
that you have
counsel.
time to get counsel, meet with counsel, all of that. I'll set
I
it for
spoke to
December
him.
6th
December 6th, so that's 12/6/24,
at 8:30 a.m. first thing in the morning.
8:30 a.m. Judge Derrick. I'm sorry about that, Judge. I apologize.
So it seems that I was pretty clear about the dates.
I talked to my lawyer, Your Honor, and I woke up at 9:43. I was aware of the date.
When did you talk to him?
I talked to my attorney by text. We've been texting since Monday.
It's interesting that you say that. So now you got me curious. So I try to remember if that's what your attorney said. So let me just take a look real quick.
Yeah, he texted me right here on. I have the messages, the thread on Monday at 5:03. Good evening. My name is Attorney Neil Brand. I was appointed to your case out of Royal Oak. I've been a lawyer for 25 years, a public defender. I am not a public defender. I have my own private law practice. A tremendous amount of experience, especially with the case in Royal Oak. I do a great job helping you. When is a good time for us to talk? I texted him back and told him my phone was broken. Please call me in the morning. That was yesterday. We spoken. We talked all the way up until this morning where he texted me and said, I'm sorry, sir. I'm sorry, sir. Judge issued a warrant. You wasn't there by 8:45. We were the first ones up. The warrant is issued. Sorry, man. I tried. Good luck. I said, can we reschedule? He said, no. He said, you got to do a turn in. So then I called down to the courtroom immediately and asked, can I come in at 1:30 to do a turn in with you? Because I didn't want to be pulled over with my daughter in the car.
Okay, so let's take a look and see if that's the same. I'm big on, Mr. Biffle, I'm big on accuracy. So let me just take a look real quick. I want Mr. Brand's take on the same situation. I just appreciate while I play this for myself, if you just keep yourself silent, and then after we hear everything, then you can comment on it. So just hang on a second. And Mr. Rosenbaum, just give me a thumbs up if you can hear this. Let's see.
Courtney Rosenoff for the people.
Neil Brand on behalf of the defendant.
Do I have Brock Biffle here?
Judge, I've made every attempt to contact him. I'm looking at my cell phone right now. I'm thinking 2 or 3 phone calls and maybe 12 to 15 text messages, maybe probably less, maybe 8 to 10 text messages. He has responded a couple of times. I have listed the Zoom number to him right here as 305-516-0819. I again did it at 7:15 this morning. The first time was last night at about 7 o'clock. I think completely evasive. So I can't, there's nothing I can do except tell you that I've reviewed discovery and I'm completely prepared and have done my best.
Okay, obviously, Mr. Biffle, that feedback from the attorney is a little bit different than what you're telling me.
Judge, I can bring you my phone right now. I have the messages. He called me. Listen, he doesn't even call, sir. He says it in the messages. The only way I communicate is by text. He says that in the messages. And he texts me again. I'll give you at 7:43 and said, all right, I will see you online at 8:30. Asking for another hearing date because I'm telling the judge I'm not prepared. And it wasn't that I wasn't going to come to court. Like I said, I just simply overslept. I didn't get off work until 12 o'clock last night. And I texted him at 11:30 when I was putting the lead line in. It wasn't that I was trying to evade you or anything. I was accepting that attorney because he sent me the message and said that he had 25 years experience in this particular case. I didn't have any complaints. It was simply on my behalf that I woke up late. I can read every last messages from then until now, from yesterday and the day before until now. I have it right here on my phone. What Zoom number do you have for tomorrow? It's a little confusing because it looks like it's 2 different courts. He called down to the courthouse to get that straightened out because they didn't have it transferred. Then when they popped it, he issued that. He gave me everything. I don't know why he's saying that. Then yesterday in the evening, he said, I can call you in a bit if you want. Okay, give me about 15 minutes, just making sure you're in a quiet place with no distractions. I don't like talking to people when there's a background noise because then it's hard to hear and communicate. Just finish up a jail call. I'm almost done. I will call you. I text back and said, first thing in the morning, I'm tired. He said, okay, I will see you in court tomorrow, though. I haven't been evasive.
Hey, Mr. Biffle, you've either been late or not shown up for more court dates than you showed up on time. So it's hard for me to give you the benefit of the doubt when it comes to this. Now, here's what I'm going to do for today. This whole Zoom process, Mr. Biffle, just isn't working. And so what I'm going to do is I'll set aside the bench warrant. I'll reset it for a PCC. It will be next Friday at 8:30 in the morning. It will be in person.
Great.
You will be here in person. If you are not here in person, then the court will increase your bond and add a tether device. I don't want to do any of those things, Mr. Biffle. I'll see you here next Friday, 8:30 in the morning, in person at the court. I've already given you plenty of warnings as to what will happen if you don't show up. Yes. Frankly, I shouldn't be doing this, Mr. Biffle. You've received so many accommodations from this court. I have shown extreme patience with you. I think long ago another court would have just made sure that you showed up by having you sit in jail. So no further conversation is needed. No more excuses, no more thanks, no more anything. Just show up for court on time, in person, a week from today, and you will satisfy your obligation with this court as far as appearances go. If you stroll in at 9:30 or 10 o'clock, you tell me you were working late. If you tell me that you've got some other things going on, I'm just going to issue a warrant, and then I'll make sure you show up by sticking you in jail, which is ridiculous, yes, Mr. Biffle. That's absolutely ridiculous. I should not be put in a position where I put a person in jail because they couldn't get their business together. I've given you specific dates. I've given you extra accommodation. It's over. You show up next Friday in person, or the rest of the time that you and I will be talking to each other, it'll be with you in a jail cell. Let's make sure that doesn't happen, Mr. Biffle. I will see you a week from today. Tell me you understand that you need to be here a week from today at 8:30. Do you understand?
Yes, I need to be there Friday, December 13th at 8:30.
Exactly. Nothing further needs to be said. See you next Friday.
Yes, sir.
All right. Looks like we're gonna get a follow-up with that guy Friday. This week's a busy week. Can't wait till Friday. I bet he shows up. I don't think he's lying. He's just not good at adulting. I think that's it. His time management skills aren't great. Breaking the Wall, thank you so much for the super chat, and hello to you right back. Thank you so much for the super chat. I appreciate it, bud. All right, moving on. We'll get next.
Are now taking two cases. Each case is in the people of the state of Michigan versus Corey Humphrey. The file numbers are 4-3540 and 3541. FH. Appearances from counsel, please.
David Champion appearing on behalf of Mr. Pumphrey, Your Honor.
Mr. Pumphrey joins us today from looks like Clare County Jail. He joins us today via Zoom. Mr. Pumphrey, are you able to see and hear us this morning, sir?
Yes, Your Honor.
All right. Mr. Pumphrey, we are here today on an arraignment for a bench warrant. This court issued bench warrants in these two files on October 31st of 2024. The court issued the bench warrants based upon a petition filed by the prosecutor that reported alleged failures to comply with the terms and conditions of your probation. Specifically, it's alleged that you were on bond awaiting a pretrial that was scheduled for November 4th of 2024, and that you failed to appear to that hearing. Also, that you were to submit for random drug testing, but allegedly failed to do so on or about October 6th, October 9th.
I mean, we got a, celebrity court today. We got Winona Ryder and Pete Davidson. It's going to be a good day.
October 13th, October 22nd of 2024. And that you also failed to appear for an ETG test at Community Corrections on that last date of October 22nd. There is also an allegation that you failed to perform community service in lieu of those fees, and that you currently owed at that time $215. Now, we can have a hearing. Typically, a violation of your of a bond could be considered contempt, which could result in additional jail and fines. However, we don't look at it as a contempt. We merely look at it as a review or, a review of your pretrial release conditions pursuant to a court rule called 6.106. Now, if we do that, we can take in some evidence or testimony, such as from Miss Alex Matsky, who also joins us today via Zoom from the Community Corrections Office over in Cadillac. Before we go any further, I should also inform you that your bonding agent, which is,
I think it's
Craig's bail bonds, has asked for, which they have the right to, have this court revoke and forfeit your bond, which is the court has signed. Therefore, your bond has already been revoked by your bonding agent. Again, Craig's bail bondsman. Mr. Champion, have you had the opportunity to speak with your client today? Or
I have not, Your Honor. As the court's aware, he's currently lodged in Clare County, and up until this point in time, we were having technical difficulties in my office communicating.
All right.
With Mr. Pumphrey.
So, do you want to adjourn to? Sorry, Mr. Pumphrey, are you currently being held in Clare County on new charges?
No, I turned myself in, Your Honor.
Okay, all right. And did you turn yourself in on just these warrants?
No, yours also. No, I didn't have warrants until your office and the failure to communicate with my lawyer and I. When he has my number, the communication has been very minimal from the beginning.
Okay, all right. So
communications with your office and your court, I've been going through this legal proceedings the same. I have the same charges there as I do here. Possession of methamphetamine, which is my serious cases through your guys' office. I haven't had any issues with Clare County. It seems like when I caught the case there and I proceeded to, how would I say this, continue to oblige and conform to your guys' recommendations, there has been disruption. For me, I don't know if it's intentional. I'm not saying it is. I don't believe it is, but it seems like there's been an intentional disruption for me in the way the court proceedings have been leapfrogging for me to comply with your guys' rulings. It hasn't been intentional. As I said, I followed all the recommendations through Clare County. I haven't had any issues until I have been dealing with your guys' court. And I don't know if it's the dates. I don't know if it's the times exactly. I believe it's a little bit of both and a failure of communication between the lawyers. But it hasn't been intentional, and it really has hindered me rather than helped me, if that makes sense.
All right, hold on.
without trying to justify anything. Like I said, I've been going through the same thing with this court, and I haven't had any issues until I had the failure with the Missaukee County for showing up, being that you guys were over an hour away from where I reside. It's still no excuse for me not to be in your courtroom. I'm not using that as a justification, Your Honor.
I got it. Now there's.
Yeah, I mean, I don't know why they keep catching them. I would just, run the other way. Run a bad route. Have the quarterback, throw the ball to the other team. Don't catch it. Easy. Terry, thank you so much for the PayPal, and Merry Christmas to you too. There he is. Thank you so much, Terry. I appreciate the PayPal. That is awesome of you. Thank you.
One thing I'm going to clarify. I'm going to look to Mr. Champion because maybe he knows the answer. Mr. Champion, I thought I heard a little bit of confusion or inconsistent statement, but maybe it was the way I asked the question. Does Mr. Pumphrey have pending charges in Clare County?
He does, Your Honor.
And so while he is there in the jail, it doesn't sound like he's in jail for any alleged bond violations out of Clare. He's only there in jail based upon these alleged violations?
No, I believe he's being held in Clare on their own charges.
Oh, okay. So
that's why he's not here today.
Okay. Mr. Pumphrey, are you being held on charges? Well, hold on, wait. Do you have charges in Clare County?
Yes, I have possession of methamphetamine here also.
All right. Did those charges come after this case was charged? No?
No, it was before. It was back in May that I had been continuing the bond with Clare County without any failure.
All right. I understand now. All right. So it sounds like what we need to do, Mr. Champion, is to set this for some hearing. Is that correct?
Correct, Your Honor.
All right. So the court enters basically a not guilty plea on behalf of the defendant in both of these two files as to the allegations. The court will have the matter set for a bond violation hearing, which we should be able to do this week. I will make a note for Mr. Pumphrey and for the record that our court, the 28th Circuit Court, specifically over in Wexford County, which is where my primary office is located and where Community Corrections is located, has had some technical difficulties during the month of November. As most are aware, beginning November 5th, which would have been after this warrant was issued, this court has had issued, the Wexford County Courthouse and all the offices, including mine and Miss Matsky's, for example, have not had telephone service, have not had internet service, did not have access to email for a couple weeks, did have to get new numbers temporarily. So we have had some difficulties. Now, those all occurred after this bench warrant was issued in both files, but there may have been some technical difficulties. So we will go ahead and again have this set for a hearing. I will also make a note that for Mr. Pumphrey, this court, the circuit court, uses community corrections for testing. And when a case is bound over from district court, there is sometimes a confusion. Miss Matsky, in this case, did you all meet with Mr. Pumphrey at all?
Yes. When he was released from jail, he was in circuit court. So the conditions with us just started with your conditions.
Okay. All right. So, and I see that the first alleged failure to appear was October 6th. I know that this court issued its scheduling order on October 4th. It wasn't filed until the 15th. So anyways, that may or may not be relevant at the hearing. All right, so the court will go ahead and remand Mr. Pumphrey. Of course, his bond has been forfeited pursuant to the rules and statutes allowed for Bragg's bail bondsman. And we should have this matter set for a review hearing later this week. All right, thank you all for your time. And again, Mr. Pumphrey, I don't have a trial tomorrow and Tuesday. I don't have anything, I think, on my docket on Wednesday. So dependent upon availability of counsel, we should be back here on the record within the next day or two.
Okay, thank you, Your Honor.
Oh, right. Yeah, that one was fun. Derval, thank you so much for the super chat. Bengals bail fund. You guys love teasing me about the Bengals, but you can't say I'm not loyal. I'm still loyal to the Bengals. I am now a Lions fan. Let's go Lions. I'm joking. I'm joking. I do like the Lions though, just not as much as the Bengals. But anyway, thank you so much for the super chat. They didn't lose today, so yeah, that's a thing. Speaking of which, fantasy football is winding down. It's gonna. There's a Okay, so the way the fantasy football is set up, there's 12 teams. Top 4 teams make the playoffs, and it's like a toss up for the last couple spots. I think there's about 8 teams that still are in it that could possibly make the playoffs, and there's only 2 weeks left. There's this week and next week, and then the playoffs start. So it's getting interesting. All right, next clip. Let's go.
Capital One versus Dana Williams.
All right, this lady, this is a small claims or this is debt collection. I put this in here specifically to see if you guys agree with me that she's using the sovereign citizen-esque debt collection lines because she kind of does, and I just wanted to get your opinion on it because I'm not going to do a follow-up if you don't think so. So this is just kind of reconnaissance on my part.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Francis, and let's see, do we have Dana Williams?
Yes, good morning, Your Honor.
Yeah, somewhere on there for me. Why don't you speak up again? You must be one of the...
Good morning, can you hear me?
Oh, there you are. Yep, thank you. Let's see, this is also set for summary disposition motion. No, non-jury trial today. Oh, no, I'm sorry, misreading the dates. Summary disposition for today.
Yes, Your Honor, it is plaintiff's motion for summary disposition.
See, Ms. Williams, did you file a response?
I'll tell you exactly. So the sovereign citizen-esque, it's just kind of soft sit. It's the people that are in, debt collection cases, and they're claiming essentially that they don't owe the money because it's not real money. That those kind of arguments, and it's all stems down from they're supposed to have a trust. So that's where the soft sit arguments kind of started, but it's kind of stemmed a little bit, and a lot of people are starting to use this now in small claims court on debt collection. So that's what I'm saying. Her argument, her defense doesn't make any sense, and you're about to hear it right now. The judge even reads it, and he's like, "I don't even know what that means," which is hilarious.
To that motion?
It's file a brief response.
Brief response, so I can find it. Supplement. Oh, here it is. Well, I've got it. Francis, I guess that what I've got is it says motion answer to the case number. Did you receive a response, or is that what you got?
I don't have a response, Judge.
No. Ms. Williams, I think what you're referring to, it says at the top, motion answer to case C24A 3629 GC. I, the defendant, request motion to dismiss without prejudice under...
Yes, that's it.
Okay. Under MCR 2.116, 2.119, grounds opposing party has failed to state a valid defense. Wait a minute. Under the grounds that the opposing party has failed to state. Okay, the verbiage is a little unusual. Ms. Francis, just for your sake, I'll just read it out loud. Under the grounds of the opposing party has failed to state a valid defense to the claim asserted against me. Exhibit A includes later billing statements with no validity of the debt. I am requesting proof of ownership of debt. Previous court paperwork states a charge off. I am requesting proof of delivery of statement to my home with proof of postage. And it says Exhibit B holds no bearing of the original contract or wet signature, generic terms that can be found on any website. No proof of contract, no valid proof of identification. Ma'am, it really doesn't fit I've got to follow what's required by the court rules for the motion for today, but I'll consider anything you want to tell me and consider, I guess, what's in writing here. Ms. Francis, I know I kind of read through it, but if there's some kind of argument, we can go into more detail over it.
I would just argue that our motion has attached to it, Your Honor, a statement showing that this is defendant's debt. It shows charges, payments. We also attached to our supplement a affidavit. So defendant's response still does not provide any valid defense and does not raise any issues of material fact for to have to continue to trial, Your Honor.
Okay. Ms. Williams, given what I just recited off, what you filed with the court as well, anything else you want to tell me with regard to the motion? I have to follow the court rules, so if it's not fitting, quite frankly, I'm going to just proceed.
I understand, Your Honor. Basically, I'm just trying to answer the fact that they haven't proven any validity of, the charge. So they have no proof of me signing any contract with them, nothing. And that was my point of writing that answer, because it's essentially the same words, verbiage that they used in the first paperwork that I was receiving from them.
Okay.
I'm also a bit confused on who owns it, if it has been sold or if it's actually Capital One. There was a bit of confusion there as well.
Okay, the documentation shown. Ms. Francis, if you want to argue, I'm looking at your attached documents while we're talking here. If you want to argue as far as it looks like what you've got is Capital One documentation showing the, I guess, the accounting for each month.
Correct, Your Honor. No signed agreement is needed for a credit card. Usage of the credit card shows an agreement between the parties under Michigan law. And then, Your Honor, this is Capital One suing. This is not an assigned debt or anyone else suing on for Capital One account.
Okay. And Ms. with regard to what you filed with the court too, you do have you're using the address 3315 Westlake Road, Clio, Michigan. It looks like all these statements were going to that address. It says Dana Williams, 3315 Westlake Road, Clio, Michigan. It looks like there were payments made periodically, showing a balance that was fluctuating. Anything else, Ms. Williams? I'm giving you a little bit of lead.
Sorry. Yeah, my concern is I haven't seen these bills prior to them sending them to me. I did have other folks living with me at the time. I don't know if that's the situation here. As far as making payments, I don't know. I'd have to see where those came from to answer that efficiently.
Okay. And it looks like you didn't provide any affidavits either for me with regard to what you're arguing is, well, and you did file an answer, it looks like, as well.
Your Honor, I did.
And Judge, I would note in her answer, she did not allege fraud, which she would have had to do in her answer.
Thank you, Ms. Frank. Boy, you're kind of catching me. You're foreseeing what I'm looking for here. I'm looking through.
I'm reading your mind, Judge.
Ms. Williams, your answer doesn't make any claim for fraud. It doesn't make any claim for, let's see, amount stated. It just says, do not know if the statement in paragraph 9 is true. The amounts claimed. This is a motion brought pursuant to MCR 2.116. Make sure I got the right ones for everybody. Yep, C9 and C10. I had a chance to review the attached documents to the motion for summary disposition, as well as I'm going to call it a response to that motion as well, that I read into the record. Motion answer to case C24A 3629 GC that was in the file as well, provided by Ms. Williams. Do find that the addresses she uses for correspondence matches the invoices, the accounts stated that are attached, monthly accounts, account summaries that were attached. I do find that there were payments made on this account. These went to Dana Williams at that address, 3315 Westlake Road, Clio, Michigan. Find also that defendants failed to provide any supportive documentation, although most of her arguments that she said she just wasn't sure about those accounts that I referenced, the account summary that were sent to that address. Based upon MCR 2.116 C9 and C10, it's obligation of the responding party to also provide documentation. There's quite frankly not even a affidavit attached in her response. And again, as I mentioned, I got to follow the rules for everybody. Do you find there's no genuine issue material fact based upon all the documentations, the pleadings are in order? Grant motion for summary disposition pursuant to MCR 2.116 C9 and C10 for the amounts stated in the complaint. Grant motion for judgment in the amount of $1,839.43. Total, looks like that covers the, let's see. Oh, yes, you're not asking for interest, Ms. Francis, it looks like? Get 0%. Accruing up to this point, I guess. Is that right?
Sorry, I didn't realize I was muted.
Oh, that's okay.
Correct, Judge. It's 0% up to now.
Okay. All right, grant motion for that total $1,839.43. Ms. Williams, I'll send you a copy of that order as well.
Okay, thank you, Judge.
You're very welcome, ma'am. I appreciate the efforts as well.
Thank you, Judge.
All right. Bye now.
Bye.
Bye.
All right, there isn't a follow-up. I'm not going to need to. There was a judgment ordered. I don't know why I thought there was a follow-up in that case. But yeah, legal fiction, I like your term better. Soft sit light instead of soft sit-esque. I think it makes more sense. All right. Let's move on. Let's just go on. No other comments are needed on that one.
All right.
All right. This is a sentencing, and there was a jury trial on this. And wait, no, this is the verdict. This is the verdict after the jury trial, and this is a great reminder that consequences or actions have consequences. Here we go.
Ladies and gentlemen, jury, it's my understanding you've reached a verdict. If so, who shall speak for you?
I guess
All right, juror number 5, juror 5, if you can stand and state your name for the record, please.
Courtney Johnson.
And if you could swear her in, please.
Courtney Johnson, please raise your right hand. Do you solemnly swear or affirm that the verdict you are rendering is truthful and correct, so help you God?
Yes.
All right, thank you. If you could pass the verdict form to the deputy, please. Thank you, deputy. You can pass this to the jury foreperson. And I'm going to ask the jury foreperson to please stand again. And I'm also going to ask the defendants and their attorneys to please stand. All right, we'll begin with Taisha Bird's verdict as to count 1, robbery. How do you find the defendant?
Guilty.
As to count 2, with regard to Taisha Bird, how do you find the defendant with regard to assault with intent to do great bodily harm less than murder?
Guilty.
Right. Now we'll move over to Thea Baker. As to count 1, robbery, how do you find the defendant, Thea Baker?
Guilty.
As to count 2, assault with intent to do great bodily harm less than murder, how do you find the defendant, Thea Baker?
Guilty.
I think you can have a seat. And everybody can have a seat, please. Members of the jury, all right, now I'm going to ask you all to stand and please raise your right hand. Members of the jury, listen to your verdict as recorded by the court. You do say upon your oath that you find the defendant, Taisha Bird, guilty of count 1, robbery, and guilty of count 2, assault with intent to do great bodily harm less than murder. So say you, Madam foreperson, so say you, members of the jury.
Yes.
Members of the jury, listen to your verdict as recorded by the court. You do say upon your oath that you find the defendant, Thea Baker, guilty of count 1, robbery, and guilty of count 2, assault with intent to do great bodily harm less than murder. So say you, Madam foreperson, so say you, members of the jury.
Yes.
Okay, you can all have a seat. Right, with regard to the attorneys, we'll start with the prosecutor. Madam Prosecutor, do you wish the jury be polled?
Yes, Your Honor.
You want the jury polled?
Yes, Your Honor.
Okay. All right. If I can have all the attorneys come forward for a second. All right, all right. Okay. Juror number 1, was that and is that your verdict?
Yes.
Juror number 2, was that and is that your verdict?
Yes.
Juror number 3, was that and is that your verdict? Juror number 4, was that and is that your verdict?
Yes.
Juror number 5, was that and is that your verdict?
Yes.
Juror number 6, was that and is that your verdict?
Yes.
Juror number 7, was that and is that your verdict?
Yes.
Juror number 8, was that and is that your verdict?
Yes.
Juror number 9, was that and is that your verdict? Juror number 10, was that and is that your verdict? Juror number 11, was that and is that your verdict?
Yes.
Juror number 12, was that and is that your verdict? Okay. Then at this point in time, I'd like to thank each and every one of you for your service. What I'm going to ask you to do is go back into the jury room, collect your items, and I'm going to be in there in a few minutes and just chat with you for a few minutes, and then we'll get you on your way, okay? So again, thank you all very, very much. And if you can give that verdict form to the deputy as you're walking out, thank you.
All right.
Number 5. All right, first of all, Council, with regard to any of the exhibits, you're gonna keep copies of all the exhibits, you're gonna take possession of all of them for appellate purposes?
Yes, Your Honor, they're on a disc, so I don't know if the court wants me to go back and grab the disc or.
You know, I'll go back and talk with the jury when we get done, and you can go back there and get it.
After they're done.
After they're done,
Okay,
okay? All right, let's set a sentencing date, and Madam, Prosecutor, what's your position on bonds?
Your Honor, I was trying to pull up the statute on bond. I can't recall what section it is right off the top of my head, but I know that once a defendant is convicted of an assault of crime, which assault with intent to do great bodily harm less than murder is an assault of crime, that the court has to engage in or under the court rule is supposed to determine that the defendant must be remanded pending sentence unless the court finds by, I think, clear and convincing evidence that the defendants no longer would be a danger to the community. And so based on that, I would indicate that, yes, the defendants are convicted and yes, they were out on bond pending trial. However, these are very assaultive allegations. The court is now in a different position where the court has been able to hear the testimony from the complainant in this case regarding the assault and how long it took place for, the injuries that the complainant received, the fact that this happened in the middle of broad daylight, and obviously, the defendants, both of them in this case, drove over to that location and sought out the complainant and allowed this to escalate to a physical assault and a robbery. And so I would indicate that they are in fact a danger to the community. And even after being convicted, now you can see that Miss Baker is very emotionally upset about that. And there's a risk of her being out on bond and with her emotions. Thank you, Your Honor.
Okay, Counsel.
So I guess first and foremost, I would just communicate that I would like the opportunity to speak to the jurors as well at the conclusion of this matter. As relates to bond for my client, Your Honor, my client has been out on bonds during the pendency of this matter. She does not pose a threat to the community in any way whatsoever. This was an isolated incident, Your Honor, surrounding some very specific facts and concerns that my client had about an investment that she was involved in.
Yeah.
My client has family and personal property and things of that nature that she needs to.
Yeah, I'll have to call you back. I'm in a mode.
Okay. She has personal property that she needs to figure out what to deal with. She has an elder mother that she's responsible for caring for, Your Honor. Again, my client does not pose a risk to the community. She's appeared here at every court hearing early. She's not a flight risk. I don't think that justice would be served to take her into custody today.
Okay, Counsel.
I join the majority of Brother Counsel's argument as well. Certain things, the caring and other things my client's not directly involved in, but I would note his lack of a record, all of his appearances, Your Honor. I'm asking the court to continue his bond in this matter, please.
Okay. Do you?
All right, the Judge Slavens definitely took a phone call during the argument. I don't understand why bond would continue after the verdict came in. I mean, they're getting jail time. They can't. There's no way around it. They're both going to jail from this verdict. So I don't understand it. That gives them a chance to essentially run. Like I don't understand why that's even an argument at this point. I know it's a thing. I just don't understand it. I mean, if you're already out on bond and you're in front of a jury for something that you're going to be going away for a few years, I don't know what the sentence is. This isn't a sentencing, but if you're going away for a few years, you have all your stuff in order when you're walking into the jury, the trial. So I don't get it. I don't get why this is an argument.
Remember that I advised both of your clients that if they were found guilty, that they could be going to jail today and to get their items in order. Do you remember me talking to them last week about that?
Yes.
I don't specifically recall that
Well, I
conversation.
said it. I said it very clearly to both of them. I think they are a danger to society. This was a brutal beating of this young man. Counsel, you can have a seat. Thank you. This is a brutal beating of this young man. I do think both of them are a danger to society. I'm in order that they be remanded to the Wayne County Jail until sentence. And if we could set a sentencing date, please.
January.
All right, now January the 9th at 11:30.
I'm available that date and time.
Okay. All right.
I accept.
I'm sorry?
I accept.
Okay, nothing further. This matter is completed. Everybody have a nice day.
Governor, may I ask one thing before we go off the record about the sentencing? Can the complainant, since he does reside out of state, would the court grant him permission to give an impact statement via Zoom if he would like to make one?
Yes, that's fine.
Thank you.
Anything else we need to take up?
No, Your Honor.
No, Your Honor.
All right, nothing further. This matter is completed. Everybody have a nice.
It was just evidence of
Yep. Actions have consequences. You rob somebody and beat the crap out of them, and then you cry when you're found guilty. I don't have any remorse for that. No remorse. Yeah. Anyways, let's move on. Legal Fiction. 10 gifted memberships. Extremely generous of you. Thank you so much, Legal Fiction. I do appreciate it, bud. Welcome to the 10 new members. Legal Fiction, that is awesome. Thank you. And the one and only Eric Martin cat. Your favorite cat. Oh, the gift that keeps on giving. That's for sure. Thank you so much, Cheshire Cat. I appreciate it. Sorry, Eric Martin cat. Man. You guys are awesome. Thank you. All right, moving on. Let's go. Yeah. You know what? And every once in a while, attorney gets in trouble. Judge is not happy with this attorney. Let's go. I think they can make that request. I don't know how often it happens. I think polling the jury is pretty much where it ends. But I know the prosecutor can ask to talk to the jury, so I imagine the defense can as well. It doesn't usually happen though. But yeah, I don't see why that wouldn't be a thing.
Okay, Mr. Galt, are you able to hear me?
Yeah.
Okay. And I know that you've got a hearing issue, so as we go through this process, if you can let me know if there's anything you can't hear, okay?
All right.
We're on the record now in People versus Galt. This is case number 244943. And if I can have counsel put your appearances on the record.
Ryan Ziegler, yes, Your Honor.
Thank you, Honor. Ravi Gurumurthy on behalf of Mr. Galt.
We're on the record here today for a status conference. Mr. Ziegler has filed a number of motions regarding evidence that's set for hearing today. Mr. Gurumurthy, I did not get your responses. Apparently they were emailed to my office late last night. I have not had a chance to review those. So ultimately, I think what we're going to end up doing today is setting this for trial, getting trial dates on the calendar, and then setting this for another date to hear the motions.
That is correct.
There are a few things that I want to get straight though before we go forward. Mr. Gurumurthy, you've been on this case since March 27th. Last hearing we had was in early August. The court sent out the date for today as a motion cutoff, as we discussed in August, back on August 19th. The transcript from the prelim was filed on August 12th. Mr. Ziegler filed his motions on October 31st. And as I said, last night by my assistant's email at 11:31, we got your response. That's unacceptable. And I understand that you have some motions to be filed as well. Again, today was supposed to be the motion cutoff. I think what we all understood back in August was that the motions were to be filed and heard on today's date. So the fact that you still have motions is also unacceptable. You've had plenty of time to do that. The fact that you're not here in person, also unacceptable. As you're aware, your client is charged with murder. This is not a misdemeanor case. So I want you to understand, Mr. Gurmurthy, number one, I expect you to adhere to the guidelines that the court sets. I'm not going to have those thwarted and create appealable issues because defense counsel is not adhering to the court's scheduling orders. I'm just not going to put up with it. So I just want everybody to be clear that from now on, Mr. Gurmurthy, you're going to need to be here with Mr. Galt in person. Mr. Galt has requested, because of his hearing issues, I think it's totally a reasonable request to be here in person. So I'm going to expect you to be here with him. I'm going to expect you to make timely filings. When the court sets deadlines, I'm going to expect you to adhere to those guidelines. And again, I'm not going to have this case side railed or have appealable issues created because you're not filing things on time and you're not doing what you're supposed to be doing. So I just want everybody to be on the same page as we go forward. So you need to get your motions actually filed. I don't know whether they've been technically filed or not. All I know is we got them by email, Mr. Gurmurthy. And then the court is going to set this for a hearing 30 days from now on all the motions. So both counsel need to be prepared and ready to go for those hearings. In terms of a trial date, I want to get that on the calendar so that this doesn't get delayed any further. Mr. Ziegler, from today's date, how long does the people need to be ready to go to trial in this case?
Your Honor, assuming we hear the motions in about a month's time and give some time to figure out how we're going to proceed after those are decided, I think I would need at least another 90 days after that point to be prepared.
Okay. So if we set this for trial in about 4 months?
That would be my request, Your Honor.
All right. And how many days of trial do you believe that we'll need?
Your Honor, it's difficult as I stand here today to put a number on it. I probably have somewhere in the vicinity of 20 to 30 witnesses that are going to need to be called.
Yeah, I agree with both you, Sherry, and MB. I would be embarrassed. He doesn't seem to be taking this as, anything really. What's up, Lone Wolf? And honestly, if I was this defendant, I would be raising questions to the judge right now about possibly getting a new attorney. It seems like he's just mailing this in. This is a last minute thing for him, and it's a murder trial. Like his life's on the line here. I don't know. Maybe he's doing an amazing job, and the defendant loves him. But I would be asking questions at this point if I were this guy.
I would anticipate at least 5 days and possibly 6 or 7 days, depending on how many witnesses are necessary, and maybe depending on the resolution of these motions.
All right, Mr. Gurmurthy, can you be ready for trial in 4 months?
Yes. So, Judge, I just had a couple of comments. The Wexford, Mr. Galt is lodged in the Wexford County Jail. The jail was hacked about 4 weeks ago, and that has caused some issues. In fact, the phones don't work there. The Zoom internet doesn't work. Mr. Galt and I, the last time we talked, we had to, scream between the plexiglass windows to go over a few things. So I just wanted the court to understand that has been some sort of an issue. The jail in the past has let me in the back, but given some of these least recent issues, they're not doing that at this time. I did file the motions. I don't know if they're filed in the clerk's file or not, but I realized yesterday that unlike Crawford County, it has to be mailed out. So I emailed and mailed it out, unlike Crawford County, where we just email them for filing. Kalkaska doesn't accept email filing. But we can have those motions. So I have 2 responses that were filed for Mr. Ziegler's motions. I have 2 motions that were filed. And then we can have those heard and we'll be ready in 4 months. And I would assume we would need 7 days, Judge.
All right. And if the jail is having security issues and not letting you meet with your client, you know what you do? You show up to freaking court. They've already transported him there. You would have had plenty of time to talk to him. I don't know. You probably could have had an hour. Who knows how long the jail would have let him sit there with you? But especially if they're having security issues and not letting you into their room, just saying, go to court. Figure this out.
All right. I guess that's an excuse. I don't accept that. We can go back and forth all day long. It's your job as a lawyer to be ready to adhere to the guidelines, to properly represent your client, particularly in a case like this. In any situation, there's always difficulties in communication. None of that is a reason why the court's receiving motions and briefs at 11:30 on the night before. I don't accept any of those as reasonable excuses for not doing what you need to do. And I expect it going forward again for you, and it's particularly a case like this, to do whatever you need to do. Otherwise, the court's going to take action because, again, I'm not going to, this is too important of a case to have it dealt with in a sloppy and untimely manner. So it's just not going to happen one way or the other. So the court's going to set this for trial at 120 days. I'm going to set this for a 7-day trial. I think that's prudent. It may take a while for jury selection. And I'd rather set a little more time aside than less. So the court's going to set this for a 7-day jury trial. I will set it for a final status conference immediately prior to trial, just in case there are any further plea discussions, and that will be the plea cutoff. Then,
oh my gosh, Alan, lazy-itis. Yes, you're right. I read. Maybe this just tells you where my mind is right now. I just read that lazy tits. I'm not gonna lie. That is what I just read. I'm like, what? That's an interesting word to call it, but sure. And then I realized that's not what you said. But yeah, thank you so much.
Again, the court will set this for a hearing in 30 days. Given the number of motions, I'm going to set like a 2-hour block aside so that we have enough time to argue all the motions and for the court to rule. My anticipation is, again, why it's so important for the court to get briefs in a timely way. My anticipation is to rule on all the motions from the bench so that the parties can continue forward with their preparation. Again, because I don't want to further delay the trial in this case. Mr. Ziegler, is there anything else I can address for scheduling?
Your Honor, just in terms of if the court's going to set aside a 2-hour block, I just want to make the court aware that I'm going to be on vacation, January 9th and 17th. So
it'll be before that.
Okay.
Yeah. But we'll make a note of that. Mr. Gurmurthy, from your side, in terms of scheduling, anything further that I can?
Judge, I'm assuming that it would be on your motion day in Kalkaska, correct?
I don't know that yet, but we'll send out notice of the date and time of that hearing.
All right. If it is, I would just prefer the afternoon, if that would work. I don't know if you're there that afternoon. If not, I'll make it work. Not a problem.
Okay. Mr. Galt, do you have any questions about how we're going to proceed with your case?
No, it's just tough doing it in Wexford County, no phones, no nothing. I don't have access to a law library. We can't meet. There's evidence that I want to see, body cam footage, interviews I want to hear, all kinds of stuff. Mr. Gurmurthy can't present that to me in Wexford County because he's not allowed out back, and no internet access. There's a lot of things that he can't go over with me at this point, It's been going on a month. No phone, no store, no law library. I've requested books, can't get law books, you know what I mean?
Well,
I'm told in Wexford I'm property of Kalkaska. So then when I write Tilly tells me I'm property of Wexford, So, I mean, I don't know who's supposed to give me law books, who's supposed to do this, who's supposed to do that, you know what I mean?
Yeah.
So, I mean, I'm kind of in a tight spot, just as well as Mr. Guramuthi, you know? He can't be allowed out back to go over things with me. We can't shout through a plexiglass window. You know what I mean? I can't send kites. We can't even send letters. You know what I mean? So, I mean,
Yeah, so Mr. Gurmurthy, obviously you're entitled to reasonable access to your client, and he's entitled to reasonable access to you. So to the extent that that hasn't happened since Wexford had their issues there, then I would expect that, you know, you need to file something with the court so that the court can issue an order that'll facilitate that access.
I understand, Judge.
Okay.
Your Honor.
Yeah.
Mr. Gall will be here till sometime tomorrow, so if he needs to meet with him in person, he can come to Kalkaska and we can facilitate that either today or tomorrow morning.
Were you able to hear that, Mr. Gurmurthy?
Yes, sir.
Okay. All right. Okay, thank you. That's all for today.
That wasn't me. I have no idea who that was. A court reporter, maybe? I have no idea. But that was not me sneezing and coughing. I mute when I have to do that. So yeah. Anyways, I think we're moving on to the last case. Last one. Yeah. This one's kind of funny, kind of sad funny. I'll put it that way. Sad and funny. It was not me. It wasn't. Lone Wolf, are you off tonight? I just looked to see to set up who I could possibly raid, and I didn't see you. Also, you're here now, and it's after 9, so I'm guessing you're off tonight. Which, yeah, enjoy your evening off. It wasn't me. All right, fine. You know what? I'll just admit it so we can stop talking about it. Yeah. All right, let's move on. This is the last case. I'm not even gonna. I don't even have to preempt this with anything. You'll pick up on this.
We will go on the record in the matter 23 CF 124, State of Wisconsin versus William Standiford. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Standiford appears by video conferencing in custody in New Lisbon Correctional Facility. We're here today for a hearing because Mr. Standiford, you have written the court numerous times requesting that the court do a judgment or amend the judgment of conviction to lower the amount of restitution taken from the Department of Corrections. And I understand your correspondence that you have written to the court in that you only receive a small amount of money put into your canteen fund or your other funds, and that once this is taken, you're left with very little amount to be able to essentially pay for necessities such as toothpaste or toothbrushes and or anything else that you would like to get. I see that you have paperwork right there, and I'm not sure if you have anything else that you want to add or you want to state before I ask anything from the state and before we move on.
It was just paperwork that's showing what they're taking from me and what amounts that they're taking. That's what I was gonna address the court and show the court.
Okay, you can go ahead and provide me with your information.
Well, I just wanted to show that I'm a special needs worker. That's what I do for a job here. And I get $15 every 2 weeks. And by the time they take everything for restitution, they're taking 50% right away for restitution. So that's down to $7 automatically. And then from there, then they take a victim witness surcharge, 25%, crime lab, DNA surcharge, another 50%. They just keep going down the list. And court costs, the next big thing I have after my restitution is court costs, which is $2,596. I'm just asking the court, when I'm released, if I can pay these things upon release, where I'm able to make some money anyway. I mean, $15 to pay for personal hygiene stuff every 2 weeks is all I get. I mean, and after they take everything out, I'm left with maybe like $2. $4 a month to live on. My family sent me money a couple times, $300 on 2 separate occasions, and out of the $300, I got like $100, $115 is all I got out of the $300 sent to me on 2 separate occasions. So I'm just asking the court not to make it so I don't have to ever pay it, but wait till I'm able to pay it anyway, if that's possible, Your Honor.
And before I ask anything from Mr. Schmidt, you shouldn't be paying, or at least it's my understanding that you shouldn't be paying the court costs or DNA surcharges or anything right now until restitution is paid.
Right. Well, if you drop my restitution, that they're gonna go right into the next one, is what I'm trying to say. You're right on that they're not doing that until after my restitution is paid, but that's what they will be going into. So, I mean, if you just stop my restitution, that's not gonna really help, because then they'll start taking the court costs, and then, and what, they'll just go down the list. And each one of those is like 50%, for court costs, 25%, and then they just keep going down the list, and so just stopping just the court, I'm asking you to stop the restitution and any of the fines or fees, maybe until I get out. So
Right, but they should not be taking fines or fees or anything, or the DNA surcharges or any surcharges right now.
No, they're not. No, they're not, Your Honor, but they're just taking just to the restitution. And then I have child support that I got a hold of Minnesota, they dropped that down to $10 a month. But, yeah, you're right. They're just taking it just the restitution, but that's 50% of anything I have sent in. And if you stop that right now, then they're just gonna go on to the next one. So
Yes.
I mean.
Yes. And I understand.
So I don't really know what he's asking. Is he just asking for everything to stop? So he doesn't have to pay his restitution. He wants it to pause until he's out. I mean, that's not how it works. You're making money, and they're going to take it from you while they can. Because once you're out, there's no guarantee that you're going to pay it. So they're going to take it from you. Now, I don't agree with them taking the money he's gifted, like from his family. I don't agree with them taking that, because that's not income. And I don't know. I feel like that should be protected a little bit. So I understand why this guy's frustrated. But I mean, he did commit the crime. He owes a victim an amount of money that they've decided on. So the guy, it's kind of hard to feel sorry for, but at the same time, I do understand where he's coming from, if that makes sense.
I understand where you're coming from, and I can't do what you're asking me to do, and here's why. I'm going to have Mr. Schmidt, he's going to read to you, most likely, as he has his computer, the statute that prohibits me from doing what you're asking me to do.
Yeah, the statute you're probably referring to is 97320 sub 11 sub C. In 2015, the legislature passed a law that stated when someone's in prison, it's the Department of Corrections that has the authority to determine an amount or percentage reasonable for payment to the victim. So the court has no authority to reduce what DOC decides is reasonable. If Mr. Standiford would want to contest that, he'd have to do something with DOC.
Yeah, so Mr. Standiford, I don't have any authority to state that there's a stay on your.
Yeah. Well, no, he makes $30 a month. He makes $15 every 2 weeks. But because of everything he owes, the restitution and everything, he only gets, what do you say, $2 out of that 15, so he gets $4 a month. And what he's arguing is he has to buy personal hygiene products with that money, which I didn't know that. I didn't know if you wanted toothpaste, you had to buy it. I thought, I don't know why. I've never been to jail, so I just assumed that all that stuff was there, but that was just, my ignorance coming out. So he has to buy his toothpaste, his toothbrush, I guess deodorant. So, I don't know. Soap, I don't know. I don't know how this works. But yeah, I can see, he can't afford that. But at the same time, it's not really, I don't know. He did the crime. It's just, you gotta go back to that. It's hard to feel sorry for people that are in his position.
Restitution, or to say that as to any fines and fees or restitution or any payments that you don't have to pay anything or limit it to just a $10 a month or anything of that nature. It's out of my jurisdiction and my authority. It's now in the hands of the Department of Corrections since 2015, because that's what the legislature did in that legislation and that statute. So your plea is really to the Department of Corrections.
It doesn't make much sense, except you're the one who sentenced me to the 8 years, Your Honor. DOC has no say in that, other than now they do. Now they're saying, no, your judge says you gotta do 8 years. Okay, well, why can't my judge, who gave me told me to pay the rent, I paid $5,000 to the courts when I before sentencing, and it's like, I don't know.
Mr. Standiford, the reason why I wanted to have the hearing is so that you can understand that. And I understand your plea. I truly do. And I understand your argument. I have those same feelings. Why doesn't the court have more authority over certain things such as that? And there are other things that I wish that the court had more authority over, in which the Department of Corrections then takes the authority after a sentencing. Okay. I understand your frustration. I have similar frustrations, but for different reasons, because I understand where you're coming from, Mr. Standiford, because I don't think that you should have to go without having personal hygiene.
I can't live on $2 a month. I can't, and it's not my family's responsibility to pay my restitution.
I completely understand that. And I'm going to tell you, and I'll state on the record, that you were the one that did pay the $5,000 towards the amount of restitution that was ordered. And it was a high amount. I don't have the total amount off the top of my head, 17,000, or it was $22,700 and some odd cents was the whole lump sum of that restitution that you share as joint and severally liable with co-defendant Janie Blackerby. And I understand that you said that you may not have known Miss Blackerby, or you may not have been specifically in cohorts with Miss Blackerby, but together this crime was committed together with Miss Blackerby. So it's a joint and several restitution owed by both of you. Honestly, you were the one who is getting hosed in this matter, if I can use the word hosed, because Miss Blackerby has not paid anything towards the restitution, and you paid $5,000, and now you are not able to survive or have certain things in prison. And I understand that you make a very small wage in prison. $15 every 2 weeks is not a lot of money.
Yeah.
And so all I can say is your direction is to write to and talk to the Department of Corrections and see if there's a way that they would limit the amount or reduce it from 50% down to maybe 25% until a certain period of time.
Well, how about modify my sentence to concurrent rather than consecutive?
Well, I can't do that, and you're not in front of this court for that issue.
No, I'm not.
So that's the only reason I had this hearing, was so that I can let you know that it's out of my hands. But I do understand where you're coming from, and I do understand your frustration.
Was that just a Hail Mary right there? What would that have to do with how much money he makes? If it's a consecutive or concurrent sentence? It's like, oh yeah, while I have you here, can you change this? Like, yeah, doesn't work that way, man. Nice try though.
Well, I don't really think you understand totally, but Mr. Schmidt seems to think it's funny over there.
I don't think he thinks it's funny. This is not, it really isn't funny. I believe that you work very hard at your special needs job. I truly do. if there was something I could do, I would. It's not in my power or my authority to do. If I could, Mr. Standiford, because I know that you are a hard worker, because I know that you're making changes, because I know that you're rehabilitating. I can see all of those things in the letters that you're writing to me. I know that you're working hard at your job and you're not making a lot of income doing so, and that you do need certain things while you're in prison. I understand that. And that's why I wanted to tell you, if I could do something, I would do something, but it's out of my hands.
No, MB. Whatever job he's working in the jail, he's helping special needs people. So I don't know if, he's maybe on some kind of work release where they go somewhere, or if he's doing something at the jail for other inmates with special needs. I don't know. I really don't know. But not him. He works. He assists special needs people.
So your step is to write to or talk to the Department of Corrections. That's the first step, and that's where you need to go.
It's a bigger bureaucracy and a lot more bullshit than I'll ever build. I can't even get through to the courts that sentence me, let alone to that bureaucracy at the DOC.
Oh, you got through to the courts. You got through to the courts, but
you're right, but there's no way the DOC is going to do a damn thing for one man. When Wisconsin's got thousands of people in prison. They're
Mr.
Standiford, one little voice, William Standiford, complaining about bullshit. They're not going to do a damn thing.
Mr. Standiford, now I have to say you have to watch your language. You are in court, but
yes.
they may. Mr. Standiford, you don't know. A lot happens with one voice and one request. And it's worth a try to write to the Department of Corrections. It's worth a shot to write to who is your agent. It's worth a shot. And or it's worth a shot to write to your agent and see if there's somebody above that agent who they can direct you to write to that person. And you have the time.
Yeah.
And you have the will and you have the drive.
I'm losing.
It's worth a shot.
But I don't have the money. If I get $2, it's going to cost almost half of the money that I get to send a letter, because the stamps are 80 cents. Hello, that's nearly half of the money that I get a month, or every 2 weeks, to send one letter that's going to be laughed at. It'll take them 2 months to get me back a reply saying sorry. The legislator says in blah 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 that you guys aren't worth it.
Well, Mr. Standiford, I disagree. I disagree with the statement that you said that you're not worth it, or that people in prison aren't worth it. I know that you may feel that, or you may feel that that's what some people feel, but I'm sorry that you feel that way. And I'm sorry that it takes a lot of money to send a letter. And now I don't feel so great that you sent so many letters to the court and there's nothing that I can do.
All right. I'll deal with it. I gotta have this almost 16 years that I have sentenced to.
All right, Mr. Standiford, I do have to move on. I have a 2 o'clock.
All right, thank you, Ms. Moore.
Thank you. We are adjourned.
All right. That is it. That is it, everybody. Yeah, I think we all understand what's going on here, and it is sad. It is sad. And I do take back my comment that I said at the beginning of this where it was sad funny. Yeah, after watching this the second time, no, don't think it's funny at all anymore. So I do apologize for saying that at the beginning of it. Probably should have watched this again before making that comment. Not exactly what I remembered. Yeah, you know what? We're going to just end it there. But that's it. that's my show for tonight, guys. I hope you enjoyed it. You guys were on fire tonight with the gifted memberships. I appreciate it. Gifted memberships and super chats. Awesome. And Terry, thanks again for the PayPal. That is awesome. Yeah. Well, I mean, I appreciate that. I like being funny. All right. I hope you guys have a great night. Like I said earlier, I've got a lot of things on the calendar this week. It's going to be a good week. I think this is the first week in a while we don't have Eric Martin though. He's still in jail. uh, let's see. Just looking real quick. I've got a Karen tomorrow. Got a sub sit on Tuesday. 2 sub sits on Tuesday. Got a sub sit tomorrow. Man, sub sits are popping up everywhere. Mr. Magoo dude is back in front of Judge Simpson this week. I think that's Friday. No, that's Thursday. Yeah, it's gonna be a good week. Good week. All right. Yeah, you guys have a great night. Let me look real quick. I looked about 5 minutes ago and no one's on to raid. I'll check one more time before I back out. I think KCC usually ends early on Sundays, doesn't she? We'll see. We'll see. Yeah, I've got nobody. I've got upcomings. We can raid if we want to go till 8:30 tomorrow morning, we can raid Judge Oldsaver. I think that'd be funny. If we raided an actual judge's court, that would be funny. But that means someone has gone into his YouTube settings and turned on raids because you have to do that because they're set to off by default. So someone went in and turned that on. That's hilarious. All right, I'm gonna stop rambling. You guys have a great rest of your night. I really hope your NFL team. Oh yeah. No members only. No. I should have said that. No members only tomorrow. Bengals play Monday Night Football tomorrow night. So if I do a members only tomorrow, well, I'll do something. It might just be a video, it might be a premiere. Maybe I'll do a short live before Biggin goes on. So I would look for around 4 or 5 o'clock tomorrow. I'll do something. It's just not going to be tomorrow at 8. I don't like canceling members Monday, so I'll do something. I think at the least I'll do at least a premiere, so we'll all hang out in the chat, and then we'll raid Biggin. That's my plan tomorrow, because the Bengals do play tomorrow night, and yeah, I'm still a Bengals fan, so it happens. Also, speaking of which, talking about my personal life, giant shout out to my daughter who was in the Nutcracker today. Yeah, so she doesn't watch the channel, but yeah, she's too young. She wouldn't watch this even if she, understood what was going on in court. Yeah, but she was in the Nutcracker today, so that's awesome. Yeah, that's it. That's all I got. So you guys have a great rest of your night, and I will see you all. Well, I'll see you tomorrow, even if it's just a short members only before Biggin. Maybe I'll just do a live. Now I'm just talking to myself. I'm rambling. Maybe I'll just do a short live before Biggin. Maybe a premiere. I don't know. Like I said, I'll do something. I'll do something for the members. It is Members Monday. Just no live tomorrow night. Okay. Now I'm talking in circles. That means it's time for me to go. You guys have a great night, and I will see you tomorrow. Until next time, bye.